Hello, welcome to my YouTube channel, Fong Law. My name is Daniel Fong. I'm an estate planning attorney. I'm certified by the State Bar of California as a specialist in trust, estate planning, and probate. In this channel, I like to discuss legal issues relevant to your daily life, especially legal issues relevant to the coronavirus. As an old Chinese saying goes, weather is unpredictable, so is life. In the past, we just said it, but we really did not know its true meaning. It was not until the coronavirus did we finally understand its true meaning. Recently, an elderly man in his 70s came to see me. He told me that his son of 40 plus years has just passed away. His son was a medical doctor. Unfortunately, the coronavirus took his life. The son was single and had no children. The sudden death of his son was like a bolt from blue to the elderly man. However, he had no choice but to accept the fact that his son has passed away. Because his son was a medical doctor, he left many assets, including a medical clinic, a house, and a 14-unit apartment for rental. However, he did not leave any will or trust. The elderly man has no idea how to handle his trust estate, so he came to see me to consult my professional opinion. Because his son did not leave any will or trust, his estate must go through a legal process known as probate. What is probate? Probate is a legal procedure to handle a decedent's estate. In California, probate is supervised by the court. It's a very complex legal procedure. You have to submit a lot of documents to the court. You have to place ad on the newspaper to notify the decedent's creditors. You also have to hire an appraiser to evaluate the value of the decedent estate. The personal representative of the decedent estate must have court approval before he or she can distribute the estate. The process takes 1 to 2 years. Probate is not only time-consuming, but it's also very costly. In California, probate generates probate fees. The assessment of probate fees is based on a percentage cut of the gross value of the estate. It's about 4 to 5%. For example, if you have a house that's worth $1 million, the probate fees will be $50,000. You have to be mindful that when calculating probate fees, the court will use the gross value, not the net value of the estate. For instance, if you purchase a house for $1 million, you only pay $200,000 and you get a loan from the bank to pay the remaining $800,000. That means the net value of the house is only $200,000 after you deduct the bank mortgage. However, the court will still use the gross value of $1 million, not the net value of $200,000 to calculate the probate fees. In the case that I just mentioned, just the apartment left by the son alone is worth more than $2 million. There's still a mortgage on the rental property and has not been paid off yet. Nevertheless, the court will still use the gross value of $2 million to calculate the probate fees. So you can imagine how expensive probate fees can be when they are based on the gross value of the estate. The best way to avoid probate fee is to set up a living trust. You set up a trust, transfer your property into the trust, and you become the trustee of the trust. As the trustee, you exercise control over the trust. When you die, your trust can avoid probate. If you only have a will, when you die, your estate will need to go through probate. What if you die without a will? If you die without a will, your estate will still need to go through probate. It just becomes more problematic because no one knows who is going to be the personal representative of your estate. Your family will need to ask the court to appoint a person to be the personal representative of your estate. Only a personal representative is appointed can probate go forward. The court will usually ask the petitioner to post a bond before he or she can be appointed the personal representative. The amount of the bond depends on the value of the estate. The greater the value of the estate, the higher the amount of the bond. So if you want to put your family through the ringer, then die without a will. That's probably the best way to make them suffer. By contrast, if you have a trust, you can name a successor trustee in your trust. When you die, your successor trustee will have full authority to handle your estate. There will be no court supervision, no probate. You can save your family a tremendous amount of time and money. In the case as I mentioned, if the son has set up a trust, it would have cost him a little more than $1,000, but now probate costs more than $100,000. Having a trust has another advantage. A trust is a private document. Unlike a trust, a will becomes a public document when you die. During the probate process, the court will open a file for your trust. It's a public file, anyone can see it. During the probate process, the personal representative of the decedent estate will need to compile an asset list. Anything owned by the decedent will need to be put on the list. The list will be submitted to the court and will become part of the file. That means anyone can see it, including the decedent's creditors. The purpose is to let our creditors have a chance to get payment for our debt from our estate. We all may owe money when we are alive, such as credit card debts, medical debts, or whatever. When we die, the law gives our creditors the right to sue our estate to recover whatever debt we own when we were alive. That's one of the purposes served by probate. By contrast, a trust is not a public document. Your creditors are not entitled to see your trust, so they don't know what is in your estate. So a trust can protect not only your privacy, but it also can protect your estate from your creditors. Some of you may ask, if a trust is so good, then everybody has already done it, right? That's not the case, however. I noticed that many people have not set up a trust yet. You may ask, if a trust is so good, why hasn't everybody done it already? I noticed that many people have a misconception that lawyers want to make money, so they push people to do trust. However, that's not true at all. If lawyers want to make money, they should advise people not to do trust. They should advise people to do wills or do nothing. If people do nothing, lawyer will make more money from the probate process. In the case that I just mentioned, I said that if the son has set up a trust, it would have only cost him a little more than $1,000, but probate costs 100 times more than that. So are there only advantages to setting up a trust but no disadvantages? Not necessarily. As we all know, you have to observe very strict formalities when you set up a will. A will usually requires 2 witnesses. However, a trust does not require any witnesses. It only requires the trustor's signature to be notarized. That makes it easier to forge a trust than a will. If you want to prevent it from happening, hire an attorney to set up a trust for you. In addition to setting up a trust, an estate planning attorney can also set up a mechanism to prevent fraud. Some people ask me, what do you think about downloading trust documents from the internet? There are many issues about downloading trust documents from the internet. One of those issues is no one will be available to ensure that trust is properly executed. If a trust is not properly executed, it may not do you any good. Let me give you an example. Some time ago, a lady came to my office. She told me that her mother has passed away and her mother has set up a trust. I read the trust and I found that her mother never funded the trust by transferring the house into the trust. A trust needs to be funded. If a trust is not funded, then it's useless. It's just a pile of waste paper. Because the house was never funded into the trust, it needed to go through probate. Why did it happen? That was because the mother just downloaded the trust from the internet. Nobody told her that she needed to fund the trust. She thought she only needed to sign her name on the trust document and everything would be fine, but that's not the case. If she had hired an attorney to set up the trust for her, the attorney would have told her that she needed to fund the trust. When I set up a trust for clients, I usually do the funding part, transferring the real property into the trust to ensure the trust is properly executed. When it comes to your estate plan, hire a professional to do it. Don't be a penny wise and a dollar foolish. If you want to know more about estate planning, you can call my office at 626-289-8299, 626-289-8299, or you can visit my website. My website address is fonglawusa.com, FONGLAWUSA.com. Have a good day, and I hope to see you soon. Thank you.